I'm Alex Grant, and this is the Law of the Case podcast for July 16th, 2024. This is a quick reaction pod about the issue of encryption, and specifically the encryption of smartphones. Thomas Crooks, the shooter in the attempted assassination of former President Trump just 3 days ago, had a cell phone that the FBI obtained and had a strong reason to examine. The problem for the last day or so was that the FBI could not get into the phone because it was encrypted, password protected. Just prior to the recording of this podcast, news reports have indicated that the FBI has been able to open the phone with Cellbrite, a common software that law enforcement uses to get into cell phones and other electronic devices. Crooks' phone was obviously important to the FBI as it is trying to determine his motivation behind the shooting. And why is that motivation important? Well, it's not because they're trying to build a criminal case against the shooter. Crooks was shot dead by the Secret Service sniper just a few moments after getting the shots off against Trump. The motivation and any other information about the shooting would be important in what is probably the most important remaining question, which is whether Crooks acted alone. If Crooks had accomplices or was part of some kind of conspiracy, it's critical to know that because the accomplices could present a continuing threat to Trump or to other people. And if there are accomplices, the FBI and federal prosecutors would want to bring criminal cases against them as well. But the question of motivation goes well beyond cases in court. There was immediate speculation on social media after the shooting about whether the shooting was staged by Republicans to garner sympathy for Trump, or whether the shooting was some kind of inside job, indicating involvement by local or even federal law enforcement. These are wild accusations with no evidence behind them, but they are part of the public discourse, and there are less extreme questions and criticisms, such as the competence of the Secret Service or local law enforcement. There are questions about whether political rhetoric during the campaign season somehow contributed to the shooting. President Biden, the Washington Post, other news sources, other important public figures, pundits have all suggested to cool down the tone of the political rhetoric. It would be nice to know whether the rhetoric had anything to do with the shooting. So there is intense public interest in understanding exactly what happened, who was involved, and what was the motivation. Just think of the conspiracy theories that are still entertained about the Kennedy assassination over 60 years after the fact. Anything about the attempted assassination of former President Trump that is not transparently resolved or investigated will be the stuff of future conspiracy theories, future grievances, future distrust. Now let's be clear. This assassination attempt will go into the history books. The photograph of Trump, whatever you think about Trump, the photograph of Trump raising his fist to the crowd with the American flag in the background will be in the history books. There is little doubt that the assassination attempt and Trump's reaction to it will affect the election somehow. So there could hardly be a stronger interest on the part of the government and society in general to get the answers behind the shooting, and in particular, the mindset of Thomas Crooks. So it was in that context that the FBI was trying to get into Crooks' phone as quickly as possible. And what the FBI ran into was the same issue that it ran into in 2016. After the San Bernardino terrorist attack, when they were trying to get into the perpetrator's iPhone. And it's also the issue that stymies, that blocks that confounds investigations of all types, the investigations that are not front page news. These investigations, while they may not rise to the level of the importance of the San Bernardino shootings or the Trump assassination attempt, might involve murder, carjacking, armed robbery, or child sexual abuse. And the encryption of phones and other digital media is one of the best friends of the worst kind of criminals. In this episode, I will go back to the San Bernardino case, and I will talk about some of my personal experiences as a federal criminal prosecutor and how important cases that I was handling were hampered by encryption. And this is a great opportunity to revisit the debate about privacy and the public interest in investigating and prosecuting serious crimes. You'll see how, at least to this point, tech companies have elevated the privacy of their users above the public interest in very serious criminal cases. Meanwhile, some of those same tech companies invade the privacy of their users for the purpose of marketing and advertising. It's high time that this issue gets the spotlight that it deserves. I'm Alex Grant, and I spent 23 years in the Department of Justice prosecuting nearly every type of criminal case the department handles. And I'm currently an adjunct faculty member with the Western New England University School of Law. I am here to give you the straight scoop on the law, and I am unafraid to tell you when the emperor has no clothes. This podcast will cover the legal issues that journalists miss because they have never stood up in a courtroom, and I will explain the law without carrying the water for either political party. So let's go back to that San Bernardino case. The shooting occurred in December 2015. So I was with the Department of Justice at that time, but I just want to be clear that I was not involved in that case. I do not have inside knowledge on it. But the public reporting shows that the shooting occurs in December 2015. 14 people were killed, 22 people were injured. The two attackers were killed in a shootout with the police. Beforehand, they had destroyed their personal phones, but there was a work phone that was not destroyed, and the FBI wanted to examine it as part of their investigation. So in February 2016, the FBI gets a court order from the U.S. District Court for the Central District of California, compelling Apple, essentially, to create a backdoor to the phone. In other words, software that would allow the FBI to open the phone because it was locked, and the FBI did not know the 4-digit passcode. And if the FBI unsuccessfully gave the wrong passcode 10 times, the phone was set to erase all of its data. Now, I should say that it is standard practice for the FBI to be getting this court order with the assistance of the U.S. Attorney's Office for that district, which again was the Central District of California. The point is that this would have been vetted by lawyers within the FBI and the Department of Justice, and for a case of importance, it's extremely likely that very high-level officials within the Department of Justice would have been involved and would have signed off on seeking that court order. So the FBI gets the court order, gives it to Apple, and Apple refuses to create the software. It's basically defying the court order. Apple says that creating this backdoor, even for a reason as important as this investigation into a terrorist attack, would create a potential for privacy invasions in the future. So at that point, a court hearing is scheduled for a few weeks later in March 2016. So just think about that for a moment. The shooting was in December. They don't get the court order until February. Apple refuses, and then the next step was a court hearing where they could argue about it some more 4 months after the shooting. A 4-month delay in an important investigation like that is itself a big problem, especially if you're trying to identify accomplices or crack a conspiracy. So you had this important clash between the government's compelling interest to get the information off of this phone after a judge has issued a court order up against Apple's concern about consumer privacy. Apple is basically taking an absolutist stand on privacy. And quite frankly, that's part of their brand. That's part of their appeal, part of their marketing to its consumer base. The iPhone is protected even if you committed a terrorist attack. At the time, as an assistant U.S. attorney in the District of Massachusetts, I was really hoping that this issue could get resolved because locked iPhones that we could not open in an investigation involving things like child pornography, online sexual predators, rapists, locked iPhones were a persistent problem. You could get a search warrant for the iPhone signed by a federal judge because you had good reason to believe there was evidence of serious crimes on that iPhone. But the search warrant didn't do you any good because the iPhone was locked. So I was really hoping that this issue could come to a head where the Department of Justice would go to the mat and say that the general interest in privacy has to yield at some point. And if a terrorist attack involving 14 fatalities and 20-some people injured is not important enough, it was hard to imagine what would be important enough. However, in between that February 2016 court order and the scheduled March 2016 hearing, the FBI was able to get a third party to help it open up the iPhone. At one level, that was super duper impressive that somebody or some company outside the government could do something that the best minds at the FBI had been unable to do, and something Apple clearly was trying to prevent. On the other hand, it meant that the legal dispute became moot. The FBI did not need to resolve the question of whether Apple could be compelled to provide the backdoor to the security on the iPhone. I'm sure Apple was quite relieved, and maybe leadership at the Department of Justice was also relieved to avoid confronting this issue head on. But the result is that 8 years later, the FBI in this Trump attempted assassination case was still delayed, at least for a little while, by a locked smartphone. That's really sad, and it has serious consequences in many cases. For example, I prosecuted online sexual predators who were having kids produce and send child pornography, online sexual predators who were finding and meeting up with kids for the purpose of having sex with them. And in many of those cases, there were pieces of evidence, digital evidence like smartphones, that we simply could not get into because they were encrypted. And the reality is that the ability of federal law enforcement, state law enforcement, local law enforcement to collect electronic evidence is far greater than their ability to open it up and analyze it. Now, in a case like the San Bernardino shooting, and in the Trump attempted assassination case, there will be no expense spared in trying to decrypt and analyze electronic evidence, and they will do it extremely quickly if they can. That is simply not the case in the vast majority of investigations. Not everything can be the highest priority. And the result is that cases that are quite serious will have this encrypted evidence that will never be opened. What that means, at least in my opinion, is that law enforcement must have a way, once they have obtained a search warrant, to decrypt and open up these smartphones in an expeditious way. And I say expeditious because some of the decryption processes can sometimes take weeks and months if they work at all. And the strength of these encryption protections that Apple and other tech companies impose on their devices is a choice, a deliberate choice that has costs and benefits. As I said, I was disappointed that the San Bernardino case did not go all the way through litigation, through appeal, up to the Supreme Court if necessary, to resolve this issue. Because that decision about how much to prioritize privacy and how much to prioritize life, safety, and the well-being of society should be done on a case-by-case basis, done by neutral judges following the law, and not by tech companies in their sole discretion. I feel quite confident that any kind of legal balancing test would work in favor of the government when the government already has the basis for a search warrant for the device. Keep in mind that the search warrant is part of the Fourth Amendment to the Constitution. The Fourth Amendment provides robust protections to ordinary citizens. There is the requirement of probable cause. That is, there has to be a reasonable basis to believe that evidence of a crime is on the smartphone. And the search warrant itself has to be limited, meaning that only the evidence of the crime can be seized from the phone. And the search warrant has to be particular, giving a specific list of items that can be seized. Fourth Amendment is a privacy provision. It's just not absolute. Just like no constitutional right, no right of privacy is absolute. And right now, we have tech companies assigning an absolute value to privacy. Keep in mind that the Fourth Amendment only prohibits unreasonable searches and seizures, not all searches and seizures. Our law makes it clear that there are very good reasons to seize evidence. And again, in the ordinary case, that evidence is being seized with a search warrant. In the San Bernardino case, Apple was refusing, despite a neutral judge having made these findings. So that's why I think in any balancing test, the government is going to win when there is good reason to believe there is evidence of crime on a smartphone. And the part that really gets me is that tech companies are so protective of data when the government needs it and has a court order for it, even when the data is for a terrorism or a child predator or a missing persons investigation. And yet they are free and easy with sharing data about you for their own commercial reasons. You do a Google search for some product, let's say camping equipment, blue jeans, or a trip to Canada you might want to take. Next thing you know, when you go on Facebook or even news sites, you're getting ads for camping equipment, blue jeans, and how wonderful Canada is. And it's very fast. How does that happen? These companies are sharing data about you to multiple companies for ad dollars and to sell you things. Their concern for privacy does not carry the day when they are trying to advance their financial interests. So we have this backward situation where privacy is protected from the government when the countervailing societal interests are at their highest, and privacy is not protected when the countervailing interest is at its lowest. This Trump assassination investigation is a powerful example of the costs of encryption and of having no easy way to get around the encryption. And again, I am talking about after getting a search warrant. The whole country is paying attention to this investigation. People want answers. The shooter's motivations in committing these crimes are very much part of the story that history will tell about this incident. As I mentioned at the beginning of the podcast, there are wild speculations about who was involved, how it could have happened, and frankly, there's a lot of murkiness. If that murkiness, if that ambiguity can be dispelled, it must be dispelled. And it may be, at the end of the day, there are questions that cannot be answered. The shooter is dead. He cannot be questioned. And in the real world, unlike an episode of Law and Order, there are often issues that are not completely clarified. But there is no room for not answering questions that can be answered. There is no room for leaving things ambiguous because we are worried about cracking a phone after there has been a search warrant issued. And while the need to find the truth feels especially urgent in this Trump assassination investigation, keep in mind that if the investigation is of a murder or a rape of someone who is close to you, finding the truth would feel just as urgent. Prosecutors and law enforcement feel that urgency in the non-headline cases, and it's a shame that this encryption issue gets in the way far too often, and that this issue remains unresolved. Until next time, I'm Alex Grant with the Law of the Case podcast. You can find the show on Spotify, YouTube, most podcast apps. And you can find the show on Facebook and Twitter, and you can send an email to lawofthecase@gmail.com.